I'm Rodger Citron. I'm a professor at Touro Law Center. This is a Touro Law Review podcast. And today, I believe this is our first married couple podcast. We have David Lat and Zach Shemtob, and we are going to be talking about Supreme Court justice ethics, or ethics of Supreme Court justices. And the inspiration for our talk is an article that they both wrote for The Atlantic back in the fall, in September of 2023. Let's just start off with an introduction. David, we'll go alphabetically by last name. Please tell us a little bit about yourself.
Sure. My name is David Lat, and I'm a lawyer turned writer. I practiced for a number of years, but I have been a legal journalist and commentator for quite some time. In 2006, I started the website Above the Law, and I was there from 2006 until 2019. And then in 2020, I started a newsletter on the Substack platform called Original Jurisdiction, which is where I have been writing since then. And I also have a podcast of the same name.
Great. Zach,
My name is Zach Shemtob. I am a practicing lawyer. Prior to that, I was a clerk. I clerked for the Southern District as well as the Second Circuit. Before that, I was at a different law firm. Before that, I was actually in academia. I got my PhD in criminology, where I focused a good deal on law and the courts. So it set me up for my later and current career.
Great. As I mentioned in the introduction, we're talking about really the springboard here is the article you wrote, that both of you wrote for The Atlantic in the fall. So whose idea was it to actually sit down and work on or write this particular piece?
I think it might have been mine. Can't remember, Zach.
I think that's probably right. We've written a few articles together, and we often, David, I think, comes up with the idea, and then I'll often outline it, and then we'll go back and forth. But I believe this one, like usual, was David's originally.
Mm-hmm. And if we can sort of put the article, you're working on it in context. This was in the fall of 2023, and was there what was the catalyst for turning your attention to the court and this particular aspect of the court?
So as people will recall, over the course of 2023, there were a number of ethical controversies involving justices of the Supreme Court. The most prominent ones involved controversies unearthed by ProPublica, the nonprofit news organization, and many of them related to Justice Thomas, including alleged financial conflicts of interest, perhaps undisclosed trips and travel paid for by very, very wealthy people, billionaires or near billionaires. I think that was the impetus. There was a lot of discussion around that. And then there were discussions around other justices, including things related to Justice Sotomayor's book sales, a controversy related to the sale of a property by Justice Gorsuch, a controversy related to Chief Justice Roberts and his wife, Jane Roberts' work as a legal recruiter.
Justice Alito.
Yes, Justice Alito also receiving free trips. I think the only justice who didn't really have a controversy was even Justice Jackson had some controversy involving undisclosed expert witness income of her husband, who's a physician. I think the only one who didn't really have one of these issues was Justice Barrett. But the issues are varying in significance, but 2023 was the year of Supreme Court ethics, put it that way.
And part of it was, for better or worse, the media smelled blood. And once they smelled blood, some of it being legitimate, which we can discuss, and others we think less so, it was kind of one thing after the other, one ethics scandal after another.
Yeah, and I want to stay on this part. That is, we'll sort of, set the story with the current court, and then we can talk about the article. To what extent, when I was thinking about, rereading your article, thinking it through, to what extent were these issues or concerns about money, and to what extent were they about something else? And does that matter what it's about?
So I do think that most of these particular controversies centered on undisclosed financial conflicts of interest or alleged conflicts of interest. But one of the key points that we made in our piece for The Atlantic last September is there have been these types of financial conflicts throughout Supreme Court history. And we posited that one reason they seem to be getting much more attention in 2023, as opposed to these older controversies from decades ago, is that we're in a different political moment right now. We're in a very populist age. We see strong strains of populism on both the left and the right. There is a much greater distrust of elites. And for better or worse, Supreme Court justices qualify as elites. And so in the past, when there were various controversies involving justices from decades ago, they were met largely with a shrug. And this time, I think people are very suspicious of excess, I put that in quotes, power and money, and the combination of them, including the idea of Supreme Court justices vacationing with billionaires.
Yeah. A shrug with one exception, which is, I'm sure, what we'll discuss.
Tell us. We might as well go there now.
So Abe Fortas ultimately resigned from the court as a result of an ethics scandal. There were actually a series of ethics scandals, culminating in the one that took him down. And his end came about on the court when he was, David, what was it? He was receiving, I believe, $20,000 as a lifetime retainer, which would then
each year,
which would then go to his widow if he died before his wife. And David, why don't you take it away from there?
So that was a situation where I think people found it a bit unseemly. And part of it, I think, had to do with the fact that the financier, Lewis Wolfson, was a convicted felon. I'm trying to remember the exact sequence of events. His convictions may have come later. But unlike the people who have had financial connections with today's justices, nobody is claiming that they are criminals or anything like that. So I think that was one difference with the Fortas situation. I think people also wondered why he was receiving this money. It was cash. So not all of the new controversies have involved cash, although some might argue there were cash equivalents, but that was another thing. And then there was also this lack of clarity over what he was receiving this lifetime payment for these unspecified quote unquote services. And so I think that was an issue. And then another issue that I think distinguished Justice Fortas's controversies from the ones in the present day is Lewis Wolfson did end up having business before the court. He had, for example, an appeal of his convictions. Now, as I recall, Justice Fortas recused himself when petitions or issues raised by Wolfson came before the court. But in the cases that we're looking at in 2023, for the most part, they did not involve people with issues before the court. And to the extent that they did, they were cert petitions that were dismissed. I think, for example, Justice Sotomayor inadvertently failed to recuse from a cert petition maybe brought by her publisher or something like that. But the thing was denied, like, I don't know, 90-something% of cases that seek review by the Supreme Court get denied. So I think those were a couple of differences between what took Justice Fortas down and the controversies that were the focus last year.
And the Fortas scandals, while we think they were genuine scandals, they were also very political. President Nixon saw this as an opportunity to replace a liberal on the court, which Fortas was very much considered, with his own. And he eventually did, Justice Blackmun, ironically enough. But in any event, a lot of this was also led by Strom Thurmond to take him out. And there was a great deal of political controversy surrounding it. And it became hard at times to separate what was a legitimate ethical lapse from what was partisan politics even then.
My impression, and I really do think I'm glad we came to Justice Fortas, because the resignation is what makes it sort of extraordinary, and in some ways I think like a relevant benchmark or barometer, in thinking about the issue. My impression in reading your article was that you would say, looking at the underlying conduct of the justice. That is, what did Fortas do, and the nature of what he was receiving, and the circumstances behind that. That my impression was that was worse than anything that any of the current justices are done or alleged to have done in terms of the alleged conflicts of interest. Can you, is that accurate? And then can you say a little bit about the sort of comparison?
Well, yes, I do think we think that Fortas was more problematic and that it was a lifetime retainer he was receiving from an eventually convicted felon who ultimately had business before the courts. And I don't think you see that type of, quasi. Now, whether it was actually quid pro quo is controversial, and Fortas would say it was absolutely not. But I don't think you see anything of the magnitude of that in the case of Justice Thomas, who say has the most controversies on the current court, and I don't think anyone has unless they're being hyperbolic has come forward to really say it's equal in that regard.
Yeah, David, anything to add or?
No, I don't think so. I think that pretty much covers it. I think those are the salient differences.
And so then, like when we, if you will, move forward or move from 1968 or so to the current moment. And I should add, for those of you who are listening, we'll have a link to the article. And the article, we're sort of talking about the first part of the article to some extent, where there's a history given of all the way back to the beginning. Marbury versus Madison, really, the first case everyone does in con law. There is this neat and helpful account, including some incidents that I was not even aware of, that had sort of, in which these issues sort of bubbled up, but then really didn't, go anywhere politically. They were sort of like one-day stories. But when we move to sort of the next part of the article, the question I think, and this is, and David, you referred to it, why? What's the staying power, or why is this something that has sort of, taken center stage for a meaningful part of our political discussion today? And this is the elites point that you mentioned, but I want to now sort of give you a chance, each of you a chance to say a little bit more about that.
Yeah, so we talked in the article about a couple of controversies from the past. You mentioned, of course, Marbury versus Madison. This was a situation where Chief Justice John Marshall clearly should have recused because it involved the validity of these judicial commissions that he himself had signed and sealed. And his brother, James Marshall, had been charged with delivering, but he didn't recuse himself. And it turned out to be a nothing burger at the time. And then fast forward a couple,
and it would not have been
century.
It would not have been a nothing burger today. If this had taken place today, people would light their hair on fire. It would have been, a huge, huge scandal.
Or the scandal I was about to mention, in 1972, Chief Justice Warren Burger had phone calls with Richard Nixon about cases that were currently pending before the court on very hot button issues, including school busing and obscenity. And then these calls became public in 1981, so almost a decade later, but Burger was still Chief Justice. Can you imagine if we found out that John Roberts had phone calls with Donald Trump about the travel ban? I think, again, people's heads would explode. But back then, it was not really a thing. People didn't really get incensed by the notion of the head of the judicial branch talking on the phone with the head of the executive branch about pending cases.
And that was nothing new. I mean, that had occurred historically, whether it was the Chief Justice or other justices communicating with the executive branch.
Yeah. The only wrinkle I want to put in, I mean, I agree with this because one of my own obsessions was the Rosenberg case, and famously or infamously, Vinson was talking to the Attorney General, as the case was being appealed before the Supreme Court. The time lag in the discovery, though, I think is also relevant to 72 to 81, but that's just sort of a quibble. the historical piece. So that's helpful to sort of provide additional context for understanding the historical piece of your article. We now turn to the political science piece, as I mentioned when we were corresponding. And let me try and keep the question short, but also ask it this way, which is, there's an anti-elite sentiment, and so to what extent, that's prevailing today or meaningful today, this anti-elite sentiment. How much do you think, in other words, what really sort of gives these instances of, if we call them lapses or mistakes, or incidents by the justices, is it about sort of the nexus of money and power? Is it about the absence of disclosure? Kind of the idea of, well, why does it take a set of journalists, to sort of uncover this or discover this? Or is it something else? But I was sort of thinking about that after, rereading the article, and I just wanted to get your thoughts on that. That is the connection between the particulars and this broader sentiment that you identify.
I guess I would mention two things, and then I'll let Zach chime in. One, just to clarify, I don't think even the harshest critics of the court are arguing that any justice's vote was affected by any of the alleged free gifts or financial transactions or what have you. That's the classic quid pro quo bribery type of thing that we are most afraid of. But going to my second point, I think the issues here, as a matter of judicial ethics, were failures to disclose. And I would say that failures to disclose can be significant in the sense that the reason we have these disclosure rules is to prevent things like the first thing, the undisclosed quid pro quos. Because if we don't know that a justice has a financial interest in something, they could be engaging in something like swinging a case to benefit an ally or to benefit themselves, and we don't know about it because the relationship was not disclosed. So I think the disclosures are really prophylactic. They're trying to prevent the kind of straight up corruption that we fear. I don't think these cases from last year involved that kind of straight up corruption. There are some attempts to try to make shadowy connections. I don't find them ultimately that persuasive. The other thing I would mention, and I don't know, we can agree or disagree on how germane this is, but in a lot of these cases, they involve conservative justices who voted for the moneyed interest. And so query whether they were going to change their vote, whether or not they got taken on an Alaskan fishing trip or a cruise to Bali or what have you.
Yeah. Are you, well, just on that last point, that is, I guess, are you making, if you will, the argument of, I get it, I see it, that is, I see what the concern is, but really, so what? Because in the end, it doesn't seem like the decision-making process was compromised here, regardless of the script.
I wouldn't go so far as to say, so what? But I guess what I would say
Uh-huh.
is it is a good thing for our judiciary, and we should not take it for granted because a lot of other judiciaries do involve these types of problems. My family is originally from the Philippines, and judicial corruption, in terms of just financial corruption, is rampant there. I have a couple of cousins who are lawyers, and they joke, oh, well, it's very fair because both sides bribe the judge, and then the judge just decides it on the merits. But it's not great. So I think our judiciary is really, and we say this at the end of the article, despite its flaws, one of the world's best. And I think the reason people are so concerned is because it is a chink in this armor.
I definitely do not think it's a so what. I think you need robust disclosure rules to guard against quid pro quo, but also because we want some idea of what people we put in positions of great power are doing and who they're associating with, especially when it comes to money. So I would, certainly resist, shrugging at a great deal of this. And I think much of the media was doing its job when they were revealing or disclosing for the justices what was occurring here.
Um, the one of the things that we now know, of course, here in 2024 is that the court did adopt an ethics code, and I'm virtually certain, David, I'm pretty sure I read it. You wrote about it in original jurisdiction. Can you, what was your, I'll just ask it straight out. What's your take on the code?
Sure. Yeah. So I actually have to say I am fairly positive on the code. I would say that overall, just to kind of give listeners an adequate sense of the media reaction, it did not get positive reviews. And the main criticism, which is an accurate criticism, is it does not contain any enforcement mechanism. So just to give listeners a background on what the justices did, they basically adopted the code of ethics that governs lower court judges, but just with a couple of tweaks to deal with things that are unique to the Supreme Court. But unlike with lower court judges, where you can file a judicial misconduct complaint and it can be adjudicated and there can be punishments, there isn't really an enforcement mechanism for this. So I think that that was the main shortcoming. So here are the reasons why I actually am positive about the code. First, and again, maybe this is the soft bigotry of low expectations, but I'm just impressed that they did something, because this is the first code adopted in the 200-something plus year history of the Supreme Court. So it actually, I think, is a big deal. And I've been watching the court for decades, and it is very, very slow to change. And there have been calls for an official written ethics code for years. And I just thought that the justices would put their heads down and hope to ride it out and hope it would all go away. So when I got the news that they had announced this code, just the existence of the code, again, maybe my expectations are too low, but I was very pleased by that. And then the second thing I will say about it is, even though there is no enforcement mechanism, now that the justices have set forth the specific standards that they are voluntarily committing to adhere to, it helps watchdogs better. It helps groups like, say, Fix the Court with Gabe Roth. I interviewed him for my podcast, where they try to call out the justices, and sometimes people agree with them and sometimes they don't, but they try to ride herd and point out when the justices aren't complying with ethical standards. And in the past, they've had to try to say, well, they're not complying with this standard, but then acknowledge technically they're not really required to. Now they are required to. Whether or not there's a punishment for it is another story. But if they do certain things, they do violate this code. So I think the existence of an actual black letter code can help journalists and watchdog groups and nonprofits and academics police the court's actions better, even if we can't file a judicial misconduct complaint.
It would be complicated in terms of the mechanics of punishing the justices. I mean, you have separation of powers issues if it's another branch doing it, and then internally, no one is above the court. So it gets very tricky. I will say I do not share David's kind of how impressed he was by the timing of this or the court doing it at all. And I think it was best reflected in the Chief Justice's introduction to the code, which was kind of saying, well, wasn't kind of saying, which was essentially saying, listen, we didn't do anything wrong or problematic, but since everyone is misunderstanding what we've done or what we've been doing, we're just putting this forward to you so that we won't have these misunderstandings. It's ultimately the public that doesn't get it, and we're just fine. And so here it is. You've kind of forced our hand. And I thought that was kind of reflected then in how weak the code itself was.
Zach, I'll stay with you on this. What would you do? And I really want to ask that without reference to the law matters, but politics doesn't. In other words, because I want to be respectful of the separation of powers concerns, but I'm curious, what could or would you do to strengthen the code, or it's legally speaking, this is about as far as we can go?
It may be legally speaking as far as we can go, but if I were, emperor, God forbid, and I could mandate what the code should be, I would have far more robust disclosure requirements. To me, disclosure is the most important aspect here, and I'm being somewhat facetious, but actually not really. What I would do is at the beginning of each term, I would have the justices each essentially announce anyone they dined with or any event they attended or anything whatsoever where there was money involved over a certain amount and say, I received it from this person at this time. And then you go to the next justice. I received it from this person at this time. A while ago, there was, I think it was the Libertarian candidate, Gary Johnson, who said that, he wanted politicians when they're on stage debating, they should wear patches. And the larger the donation they got, the larger the patch should be. And it should name not only, the amount that was donated to them, but the entity that donated it. In my ideal world, I would like something similar to that for the justices.
So Justice Thomas will have a Harlan Crow sticker,
exactly.
and Justice Alito will have a Peter Singer. It Singer, like a sticker?
Would open the term by saying, now let me discuss my dealings with Harlan Crow. They consisted of the following.
A Paul Singer, excuse me.
Yes, for something you introduced by saying this is somewhat facetious, I see that you've given the matter a fair amount of thought. I'm impressed.
Disclosure and transparency in general, I think both of us have given a great amount of thought to. And I do think, speaking now entirely seriously, given the position that these individuals are in, one of the first requirements, first responsibilities should be as open as possible. And that involves, as robust a disclosures as you can have. I don't want to, get into every aspect of their personal business, obviously, but I don't really have tolerance for the idea that they can, decry privacy interests or anything of that nature when it comes to these matters, because, then you can decide not to be a Supreme Court justice.
Yeah. Let me try and sort of, turn us back to politics, or the politics of the issue, because, I don't disagree that we are in a populist moment, as David was saying sooner. And it seems to me there's two dimensions to that, at least. That is, one is the anti-elite piece. The second is the hyper-partisan piece to that. And so I wonder whether that is, whether the second, the hyper-partisan piece, sort of, makes anything we do in this area, like we can't get out of this circle or cycle that we're in, and sort of, what that means for how we think about the court as an institution, for what we think about with justices. Because part of me, very seriously, Zach, in sort of thinking about, let's say the announcement was, I had 3 dinners with Harlan Crow, or I took a trip and whatever they were, and then I feel like then we're off to the races, in our political climate of, see, we told you that they're corrupt, that they're partisan, that this is the way things work. And I'm almost speaking to you, personally, in a way, because I sort of, really, how do we get out of the hyper-partisan cycle? Because we know that there's Trump cases before the court. No matter what happens, they are going to be controversial. There's no neutral solution, or neutrally, solution that will be perceived as neutral. So I'll stop and hope there's a question in there.
Well, now we have. I was just going to say, we're, as you said, we're already there. Now we have the hyper-partisanship, but without enough robust disclosures. So I'm trying to at least make it even. But David, sorry, I interrupted.
Yeah, so on the issue of hyper-partisanship, that is a huge problem, and obviously it's not limited to the judicial branch. And it's just getting worse and worse. I think Pew Research has been following this since the 90s, and it just keeps going higher and higher, the political polarization. Now, we may see in the short term something that looks like the court backing away from politics, and here's what I mean. Many people are predicting, based on the oral argument in the Trump case involving the attempt to disqualify him from the ballot in Colorado under Section 3 of the 14th Amendment, many are predicting that Trump is going to prevail in that case. And then just recently, the Supreme Court agreed to hear a case in which Trump is making a very broad assertion of presidential immunity in the D.C. election interference case. And many people predict that the court, by a large margin, is going to shoot that down. And so a lot of people have been wondering, and I now kind of tend to agree with them, that maybe there's some kind of grand bargain here where the court, by a lopsided margin, not a 6-3 Republican appointee, Democratic appointee margin, but the court by a large margin will keep Trump on the ballot. And then the court by a large margin will reject his immunity claim and pave the way for him to go to trial. And so at least temporarily, the court, which has been embroiled in controversies over abortion and affirmative action and guns, will be able to say, hey, look, we all got together, or many of us got together, and we decided in a unified or near unified way on these hugely important Trump cases.
Yeah. And that will, just I want to finish the thought, which is, that will institutionally give us a little more credibility or boost the
Maybe.
idea of
That's the hope.
That's the hope that institutionally, we're not, in the words of Justice Barrett down in Kentucky, a bunch of partisan hacks. Tell me, after the article was written in the fall, how was it received? Did it? I'm just curious to see, whether it generated, whether through the readers or your own sort of professional opportunities, what kind of conversations you had about the article.
I think it was not well received by a lot of people on the left who are critical of the court. I think one of the things we did in the article, just in terms of describing the populist sentiment, is we linked to a column by David Brooks and quoted him just on the very straightforward point about just this populist age we're living in. And I think someone on the left tweeted, "Oh my goodness, a David Lat article quoting David Brooks, like shoot me in the head," or something like that. So it wasn't universally praised. But I will say this, and maybe this is an indictment of our article. I got a couple of private messages from not justices, I wish, but judges. And they said, "We thought your article was right on."
Yeah, I mean, ultimately, as we've discussed, the article took on a, historical perspective, and we think reached a fairly moderate conclusion. And so there, besides, what David mentioned, the, tweets that were a little over the top, to say the least, it was generally well received. And we did not get, a great deal of flack or criticism, because I think most reasonable folks read it and said, at the end of the day, this is a very interesting phenomenon historically, and we may, disagree, with the way it came out, but I don't think our conclusions or ultimately our position was strong enough to invoke a great deal of fury. Now, if we had advocated, the justices announcing from the bench, their disclosures at the beginning of each term, there may have been a different reaction, but we did not do so in this article.
Well, right. That gives you something for the next cycle in the fall. David, because you sort of brought it up with the two Trump cases, do you feel like, and this is sort of a broader question, but it relates to how much we may continue to sort of zero in on, the conduct of individual justices. Do you feel like with the court's docket this year, which of course does have these two election-related cases, but lots of other cases, that there may be the court may be in a position to be able to at least put a little more space between, it and the institution of the court and politics. I just am curious about your thoughts on that. And
I would agree with that, Roger, because if you compare what they had at the start of the term in terms of their docket to recent years where they tackled abortion, guns, and affirmative action, this was looking like a more chill or less politicized term. And in fact, Zach and I early in the fall were trying to shop around an op-ed saying something like the Supreme Court term is really boring. And that's a good thing. And we were trying to argue that the court was turning down the volume and stepping away from politics. And then, glad we didn't place that article because lo and behold, they accepted the two Trump cases, which could not be more political. Now, look, I think they will try to resolve them in ways that are nonpartisan, as I mentioned earlier, but it's not turning out to be a sleepy term. That would have been a bad prediction.
Yeah, I'm happy that idea was not ultimately accepted and that article was not published. But I kind of wanted to go back just for a second to the hyper-partisanship. I think as much as the court may or may not try to tamp that down or, help alleviate that, ultimately the end to hyper-partisanship is not going to come from the Supreme Court, right? It's going to be a result of much larger social factors, many of which I don't think we could even predict at this point.
yeah, yeah. And even I think in the way I was thinking about it, it was more, can the court avoid sort of being burned rather than can the court extinguish?
I think
Okay.
even if they made it the most boring term possible, say they only took up ERISA case after ERISA case, I mean, maybe it would be a little less of a fever, but I still think that folks would point to the case and say, oh, can you believe the court did this? Can you believe the court did that? Because I think it's ultimately, a symptom, I'm not sure that the court's decisions are what's creating this hyper-partisan environment. They may not be helping. And I think often they may well be partisan, especially from certain justices. But do I think, that it's a major factor? I'm not convinced it is.
Mhm. Let me, here's how I'll try my last question. And I feel like if there's, anything that you want to go back and address, that you want to elaborate on, by all means, please do that. But the question I was going to ask is, as to the court and ethics, that is an ethics code for justices, do you think that is with the adoption of the code, this issue has passed? That is, and I could ask it this way: do you anticipate either or both of you really writing about it anytime soon, like in the next year or two, or at least there is a code, you can think what assess it for its merits or limits, but this is about where, as far as the court is going to go, and so the issue is more or less resolved.
So I have 2 points. One, in terms of what the court could have done, I would point out that there were various proposals of things that they could have done on their own initiative. So even if there are separation of powers issues that prevent Congress from policing the court other than by exercising the power of impeachment, some people were saying, well, the justices could set up an inspector general for themselves, or they could set up a tribunal of lower court judges to pass on their ethical issues or something like that. So it is true, in fairness to critics of the court, that the court could have done something voluntarily. And remember, again, this code was adopted voluntarily under pressure, perhaps, from media, and there was also proposed legislation at the time that they did this. So there was pressure on them, but they did act, I would say, quote unquote, voluntarily. I would just say, in terms of Supreme Court ethics, this is going to be an ongoing conversation. So you mentioned, well, when am I going to write it? When are we going to write about it again? Well, I just earlier today, this is Friday, March 1, I published a story on Original Jurisdiction about a controversy involving Justice Thomas hiring a law clerk, a young woman named Crystal Clanton, who almost a decade ago allegedly sent some racist text messages. And the text messages were published, came up in the New Yorker, which was doing a profile of the very conservative nonprofit that she used to work at. And so people are wondering, is Justice Thomas's hiring of this woman with a public history of writing these racial texts, allegedly, she denies it, or she, well, that's a little complicated, footnote that, or read my story. But people are saying, does his hiring of this person with allegations of racism call into question the impartiality and the fairness of the judicial system, especially for minorities? People say, well, is a Black litigant or lawyer going to feel they're going to get a fair shake from the Supreme Court if there is this woman who's working as a clerk there who sent a text saying, allegedly, I hate Black people? So I think as long as we say in our Atlantic piece, as long as the justices are human, we will have ethics controversies. They are not AI creatures. They are people. They have spouses. They have finances. They have all these things in their lives. They have friends. They take trips. And we are inevitably going to have an ongoing conversation about their ethics as long as they continue to be human.
Thank you. Zach?
I agree entirely with that. And sometimes the judicial scandals are overblown, but sometimes they're entirely legitimate. And I think ultimately we're one judicial scandal away from it starting all over again and again and again, at least in this hyper-partisan age.
Well, I do think we've ended at the right place. That is, and I thank you for your time. Of course, this could also be like, one of those 19th century, until next week. We may have to tune in again. Anyway, thank you both for your time. I really appreciate it. And you're taking the time to talk with us and enjoy the discussion. Thank you.
Thank you, Rodger.